Welcome everybody to day 2 of the LA Foyt Foundation's webinar, Access and Privacy Tips for Local Authorities. Today's session is for the municipal sector, practical tips and tricks. My name's Alex LaRocque. I'm the Manager of Compliance with the Saskatchewan Information and Privacy Commissioner's Office. And today we have 4 wonderful experts in the field on a panel today, and we'll just go around and introduce them. We have Bukola Afolabi, Legal Services Advisor with Municipalities, Saskatchewan. We have Michael Morris, Director of Legal Services, Saskatchewan Association of Rural Municipalities, or SARM. Colleen Christofferson, Manager of Advisory Services, Ministry of Government Relations. And Aaron Orban, Executive Director of the Access and Privacy Branch, Integrated Justice Services. Aaron also serves as the Chief Privacy Officer for the Ministry of Justice and the Ministry of Corrections and Policing. So welcome, you guys. You have joined the webinar in listen only for all the attendees, which means that your microphones are on mute. And the webinar is being recorded and will be available on our website in the near future. All the webinars from the 4 days this week will actually be available, and we'll have those up soon. We encourage all of you to follow us on Twitter at SaskIPC and use the hashtag LA Foyt Foundations for conversations and information about the webinar series this week. The layout for today's session is going to be a series of 5 questions that I'll pose to our panel, and hopefully we'll have some fulsome discussion around different topics that hopefully you guys will find valuable out there. We do encourage you guys to use the questions pane. You can post some questions to the panel, and some of the questions will be answered during our presentation today if they're on point with what we're discussing and we can fit them in. If not, we will save most of the questions till the end. And we just wanted to let you guys know as well that in the chat function, we have included a link to the LA Foyt Act and then also the guide to LA Foyt to help you as you guys are listening today. So let's maybe get rolling, and we'll start with our first question for discussion. What obligations exist? And I think I'm going to pose this question to start with to you, Colleen. What obligations exist in municipal legislation that local authorities should be aware of when it comes to access to information and protection of privacy?
Well, that's a really broad question, and I'm sure that we're going to fill this in and not get all of it in one answer. But to start with, I think the specific legislation that you need to look at is the Municipalities Act and the Cities Act and the Northern Municipalities Act 2010. And we look at the specific records of Section 117 in the Municipalities Act, 91 in the Cities Act, and 133 and 34 in the Northern Municipalities Act, kind of lists specific things that we're able to give access to, for sure. Things like minutes and contracts, resolutions and bylaws, accounts paid, employee and consultant reports, public disclosure statements, oaths of office, financial statements, and etc. So you have to kind of take a look at all of those things. In addition to that, there's other portions of those pieces of legislation that also provide other things that might be open to public access, like the assessment roll at certain times of the year, or depending on what council determines, tax certificates, people want to know tax information. So that's the kind of thing you need to be aware of. You also need to be aware that you need to protect the privacy and personal information. So it's very important to also take a look at things like the Local Authority Freedom of Information and Protection of Privacy Act. So there's many pieces of legislation that might apply in each circumstance. Also, if you have other specific legislation like the Tax Enforcement Act, the Local Government Elections Act, those kinds of things, you'll need to take a look at those if the request for information deals with any of those specific topics, because they will may have some specific areas that are open and available and where they give direction for. So that's kind of just a brief outline on kinds of things that you might need to look at.
Thanks, Colleen. I had actually done a little checking too, and at our end at the OIPC, and you know, we've got quite a few reports available out there as well that municipalities or local authorities might find helpful in looking at, because we do see quite often at our end when we're doing reviews, especially reviews where people are trying to access records. And it kind of looks through the process of our review that the local authority maybe has missed some of those provisions that you're citing in the Municipalities Act, the Cities Act, etc. So I just wanted to throw out there a couple of review reports that listeners might want to check out. One good example is Review Report 084-2015. And in that case, the applicant was looking for access to a number of records, including a copy of a contract between the city and a third-party business. And the city applied the third-party exemption 18(1)A all the way through to C to the contract and withheld it in full. And during our review, we found that none of the exemptions had applied. But more importantly, what we found is that it looked as though the local authority had missed subsection 91(1)A of the Cities Act, which provides that any person is entitled at any time during regular business hours to inspect and obtain copies of any contract approved by the council. So we pointed that out, the commissioner pointed that out at paragraph 33. So that report is helpful. Another one that is a bit older, but even more detailed on this whole notion of where LA FOIP fits in with other governing legislation is Review Report 122-2014. And similar to the other case I listed, that one, the applicant was looking for an agreement between the village and the third-party company that they were doing business with, and the village denied access, again under the exemption in LA FOIP third-party information subsection 18(1)C. And paragraph 16 through 23 is really interesting in that report because it goes into a lot of detail about subsection 117(1)A of the Municipalities Act, and also sections 3 and 4 of LA FOIP, which get into records that are available to the public and existing rights that are preserved. So that report's really helpful to look at with the intersection of the Municipalities Act and LA FOIP. So those were a couple that I came across that I thought that the listeners might be really interested in.
That's very good, because we do refer to some of those reports that gives you the details and what to look for. So that's very helpful. The other thing too that members of council might want to be aware of in the protection of privacy is the fact that municipal legislation requires that a council member keep in confidence matters that are discussed in private until they've been discussed at a public meeting, or even matters that are supposed to be discussed in private at a council meeting. So even prior to all of that, they need to think about those kinds of things that they need to keep in confidence and when they need to keep it in confidence. So I think those things are important too.
Yeah, exactly. So maybe we'll move on to the second question. If anybody has anything else to add to the first one, jump in. If not, we'll move on to the second question. This one's probably it's going to be a mixed bag, so this should be interesting. What are the most frequently asked questions that municipal administrators come to you with, and what advice do you give them? So maybe we can all kind of take turns answering this one. Mike, did you want to start?
Sure, yeah, I could do that. Yeah, so I took a look through my emails, see what's come in over the years related to requests of this nature. Interestingly, the most common questions, or at least I should say, the most frequent answer was, well, actually, we don't need to look at the Local Authority Freedom of Information and Protection of Privacy Act. This dealt with in the Municipalities Act. So a lot of questions around the minutes, for example, which of course the public's entitled to see once approved by council. Also lots of questions respecting contracts or agreements that the RM's entered into. And again, that's dealt with quite simply in section 117. You know, if the RM enters into a contract, then the public's entitled to see it. Also, an issue actually that comes up frequently in relation to that is settlement of legal proceedings. Frequently, it's pretty common practice for lawyers to insist when there's some kind of a settlement of a dispute that the parties have a clause in there saying that it's to be kept confidential. And so I always point out if it's litigation I'm involved in that, well, that's really not practical, possible that the public's entitled to see. If we settle a lawsuit, that's a contract the RM's entering into. And so there's no point having a confidentiality clause in your agreement. So that provision of Section 117 of the Municipalities Act extends to even contracts or agreements entered into to settle legal disputes. So that comes up fairly often. And then, of course, accounts too. People are often wanting to see what was paid to somebody. And of course, the advice to the RM is always, well, if you paid the account, the public's entitled to know how and where you spent the money. So actually the most common ones really, as I say, fall under Section 117 of the Municipalities Act. But there are others. For example, we often get questions about can a municipality or can a person rather access permits that are issued by the municipality? And the answer is generally yes. It doesn't qualify as personal information. If you look at the definition of personal information in Section 23 of, I'll call it LAFOIP for short, you'll see that it doesn't include information respecting permits that have been issued. So things like a development permit or a building permit, say a subsequent owner of the property, for example, is entitled to see. One question I have, which I haven't necessarily come up with the answer yet, is whether it would be appropriate in cases like that to, if say someone's a neighbor or a subsequent owner of property, if they ask to see a permit, should the municipality at least redact or black out the information around the mailing address, for example, if it's shown on the permit of the person to whom the permit was issued. So I suppose a safe thing to do would be to do that, right? Because of course, the home or business address is considered personal information. So if some, as I say, for example, say a subsequent owner of property just wants to see the permit, or if a permit was issued for a property, it seems to me that it might be a good practice to black out the address information. But otherwise, permits are the public entitled to see. We get a lot of questions around correspondence with legal counsel, which of course, pursuant to Section 21 of the Act, is the RM is, or the municipality, I'll say, is entitled to refuse access. They're not obliged to. They can waive the privilege if they wish, but they're certainly entitled to refuse access to that kind of a record. And then another surprisingly common request related to information respecting employees of the municipality. And so I looked at the, sort of the nature of those inquiries. And so the basic thing is that generally, and I was looking it up, so information that relates to the employment history of an individual is not, or is considered personal information. So, and I think I would include in that things in an employee's file generally, but so there's a specific exception created in section, that's in 23.1, by the way, of the Act. Section 23.2 makes an exception for information that discloses the classification, salary, discretionary benefits, or employment responsibilities of an individual who is or was an officer or employee of a local authority. So basic information like what are the job classifications, what do they do, what are we paying them as taxpayers, what are we paying these people? The public's entitled to know that kind of information. But anything beyond that, and this has often come up, people wanting to know if a particular employee was ever written up or something like that. Well, that's not something that the municipality should be disclosing to the public. or permitting access to. So anyways, I was kind of surprised when I went through all of the requests, because that came up quite often, these questions around employees. And typically, from what I understand, motivated because ratepayer is not happy with the way someone's grading their road or something like that. So, but and then another interesting subject matter that's come up often has to do with when the municipality is seeking public input, and often they're required to seek public input before making decisions. So, for example, say land use and planning decisions, and there's a need to have a public hearing or to invite public representations from the public on what council should do. We often run into situations where people are submitting or making submissions to council in writing, but asking that they be kept confidential. They don't really want, the other people to know that they said this. And so an important thing for municipalities to understand is that anytime they're making a decision respecting something that affects the rights or interests of one ratepayer or individual, they have a duty of fairness to both to that person and to anyone else who has an interest in the subject matter. And among other things, that entails this obligation to let the one party know the case they have to meet, or each party know the case they have to meet. And so what's important here is that to understand is that people can't just make submissions on issues like that, and land use and planning is probably the best example, on a confidential basis. And so what I advise municipalities is that if you get someone making a submission like that and they say they want this kept confidential, what you need to do is return it to them and say, we can't take this into account unless you're prepared to make your representations public, because we have a duty to, all the information's got to be laid on the table so that anyone who has an interest in this subject matter has the right to see what's being said and to respond. So it's kind of an interesting, it's not specifically dealt with in the legislation, other than there's a number of places where they reference, communications sent explicitly or implicitly in confidence. And again, if it's intended to influence a decision that council has to make, then it can't be, the submission can't be made on that basis. So, I think, that's a good list anyway of some of the inquiries we've had over the years. Hopefully that's of some help.
Well, what's awesome, Mike, is that your conversation there, what you were just sharing, has sparked a lot of questions. So yeah, there actually is a question directed right to you.
Okay.
Can a council come to the RM's lawyer directly to ask to see communications between the RM's administrator and the lawyer, so councillor can see what has been communicated? Can council come to the RM's lawyer directly to ask to see communications between the RM's administrator and the lawyer, so council can see what has been communicated?
Yeah, I would say, I think what they're meaning is a individual member of council approaching legal counsel for the RM or for the municipality. Yeah, I would say that's not an appropriate way to go. And this it's an important point, which we have to always try to convey to when we get calls from individual members of council. Our client is the council as a whole, or the municipality, right? And so I would think that if there's some question as to what the communications have been between administration, who's writing on behalf of the council, to the lawyer, that request should be made of administration to provide that. It's best always that communications go through the administration. Yeah.
Awesome. Thank you. So what are some other most frequently asked questions for Aaron, Colleen, and Bacola?
Well, I could jump in. Access and privacy branch, we tend to get less specific questions like the ones that Mike had provided examples of. We tend to get a lot more sort of general questions, and I think one, we looked back through the inquiries that we've had over the last few years, and we tend to get a fair amount of questions on a couple of themes. One of them is sort of the idea of, should we treat this as an access request? And I think it comes back to to Colleen's point before about looking to the municipal legislation, Cities Act, those pieces first to see, are these things that may be considered public under those pieces of legislation. But when it's maybe not so clear, our advice typically is to treat those kinds of requests or questions maybe that are even coming in as if they were, and remember the duty to assist that exists under the FOIP. So to respond openly, accurately, and completely, and then act on that to help the applicants out. And also remember that the FOIP doesn't replace those other procedures for access to information for records that might be in the possession or control of the local authority. I think one of the things that's a big difference between FOIP and LA FOIP, and a real key piece that can help you make that determination, is the $20 application fee. So under FOIP, there's no fee for submitting an access to information request. In LA FOIP, there is. So, if you're getting that in, if you're getting the $20 and, it sort of looks like an access request, then clearly you're going to treat it as one. But if you don't have that $20 and it's maybe not so clear, then I think that's really where the duty to assist kicks in, and you start to, that's when you need to reach out to the applicant and do some clarification, figure out, what it is that they're looking for. Is it something that you can maybe provide access to informally, or is it one of those situations where the formal process really needs to kick in, where there's information in the records that may be required to be withheld under the legislation, or information that you might apply the discretionary exemptions to, so you'll need to rely on that formal process. So we get a fair amount of those questions. The other one comes back to points that Mike was touching on around personal information. We get a fair amount of questions about clarifying what is and is not personal information, and I think those sorts of the motivation around asking those questions is coming from people being concerned about the potential to violate privacy rights if they make information public or they disclose it as part of a request. And that speaks to that whole balance between access and privacy. Mike was talking about the sections before. It's a very broad definition of what's considered personal information under the legislation. Really, it's recorded information about an identifiable individual. So it's not necessarily, the name doesn't necessarily have to be involved, but when it is, that oftentimes makes it clearer. But if you have enough information, even if the name's not there, that you can reasonably identify somebody, then it might be personal information. So we typically encourage people to err on the side of caution. I think it's better to have to answer for why you didn't release something and say, well, it's because we were concerned that we were going to potentially violate somebody's privacy, than have to answer on the other end of that. And I think really the best advice there is when you're uncertain, reach out, contact us, contact legal counsel, and just make sure you're clear on whether or not it actually is personal information.
Thanks, Aaron.
I'll just like to add to all that has been said by Colleen, Mike, and Aaron. So we also do get quite a fair bit of questions, but most of it has been covered. So I'll just mention one or two. So we'd usually get from administrators questions around access and request for information when it comes to utility bills of other authorities. And when I get such questions, my advice would usually be that to make an early assessment of whether a third party is involved. Because usually when you're saying that you're getting questions as to whether to release information to another local authority, usually it becomes a third party situation. So in that case, you have to make a quick assessment as to whether what you need to do is require consent from that other party, or see if the other local party has more interest in that situation, and you'll be looking at transferring the file to them. But whatever you decide to do, you have to make the applicant aware of what you've decided. If you're transferring the file, then you need to provide notice to the applicants as well, so they know that their file has been transferred to a local authority that has more interest in that file. Another question we normally get would be regarding what information should be provided and which one should be excluded. I know that we've touched on that as well, but my advice when I get such questions is usually, I would usually tell them that to familiarize themselves with the LA FOIP, and because of the fact that a lot of provisions is in there and has been specifically spelled out as to what sort of information can be excluded when you're providing or releasing information to an applicant. So for you to be able to determine what you want to be told or what you want to release, then a good understanding of that act is important so that you can determine which one you need to release and the one you need to withhold. So that'll be my addition to all that has been said.
You know, just to add on to what you just said there, Bacola, determining, you know, what to release and what to withhold, and getting yourself familiar with LA FOIP. It might be a good time to just mention a resource that we have on our website, the guide to LA FOIP and also the guide to FOIP. And in there, we have a number of the tests that can be used for the different exemptions if a local authority is looking at whether or not to withhold certain records or certain information. And you know, they might find it helpful. There's some terms defined there. There's some precedent from court decisions and previous reports by the current commissioner and previous commissioners. And that's under the resources tab on our website. So that might also help, along with familiarizing themselves with the legislation.
Thank you for providing that. I'm sure that'll be very helpful.
Gotcha.
We also get questions, a lot of the questions you've already talked about, but a tax enforcement question. Is the tax enforcement list, should it have names on it? And what we look at and talk to them about in that regard is that legislation doesn't require the names. It only requires the land and the arrears. So anytime that you want to provide additional information than what is required, you really need to take into consideration all of the legislation, the FOIP, and all of the other things to see if you're releasing personal information. So attaching the names to an address may definitely fall in that section about personal information, section 23 in LaFloip. So in our sample on that particular case, we say, no, don't have the names in there. It's not required. And in fact, the legislation only requires that you submit it to the head of council, not to the whole of council. It is published in the paper, so you know that that document in and of itself is going to be a public document. So I would be extremely cautious about adding additional things that aren't required to be in that particular document. So that is one of the questions that we get, and especially this time of year when people are thinking about tax enforcement for sure. Something else, and I know Mike, you talked about this as well, is can they really know my salary? Yes, they can really know your salary. You're a public employee, they can know your salary. Can they know the council's remuneration? Absolutely, it's very clear that they can know the accounts are paid and what those things are. So, and that's in 117. So those things are to be able to be accessed easily and for a reasonable fee. So we always say, we also get asked what's a reasonable fee, and we may suggest, what does it cost you to print that document out, and how long did it take you to get it? You might want to use the guidelines and the regulations for LaFloip and take a look at what they're saying, the prescribed fees in the case of a Form A coming in, which is a formal form requesting information. So Yeah, we get asked that quite a bit, but we really encourage that you take a look at what your actual costs are, because that information is to be available to the public. So, the other question, another question that we get is about emails. Are emails accessible to the public after they've been sent between the administration and council, or between another party and the administrator? And of course, anything that has to do with the municipality is a record of the municipality, whether it's on a personal computer or on your phone. Text would be available. So the records of a municipality, no matter where they're held or kept, they don't have to just be kept in that municipal office. So those are some of the questions that we get asked, in addition to, I think they're all common questions that I'm sure we all hear about.
Colleen, I heard you mention taxes, and it is that time of year. And one of the questions posed from the audience is, can anybody order a tax certificate, or do they have to be a lawyer or a financial institution? Can any of you answer that?
Yeah, anybody can ask for a tax certificate, anybody. And I was going to say that when I first started as well, as these documents that are accessible by the public, it's by the public, not just by a voter, or not just by, you know, somebody that lives in the municipality. This is anybody. Anybody can ask for these records, and they're accessible, or should be.
Mhm.
How long do permits need to be kept on file?
I think that would, well, Colleen, maybe you know that, I suppose that would be governed by their documents retention policy, right?
Right.
I'm not aware of anything in the legislation that says that permits have to be kept for a certain period of time. One would hope that building permits would be kept as long as buildings around, but I'm not so sure about that. But do you know anything about that, or is there?
I agree with you. There isn't any specific time. I think they should address it in their bylaws for their record retention schedule. And I should make sure whatever the permit is, that they at least keep that permit in their possession and in their records until after its effectiveness, at least, at the bare minimum.
Yeah. So for things like a development permit and a building permit, that could be a long time. But, you know, I think the big challenge would be, how do you organize your files so that you can find those things years later? And I know that from doing litigation for RMs, that it's sometimes hard to find these things that you need 20 years later, especially, you know, litigation over building inspection problems or something can often happen years after the building was constructed, sort of thing. So
yeah.
And I think we have some tips and tricks coming up later, and I think we might talk a bit about records retention at that point too, right? There are a ton of questions. Sorry, Aaron, go ahead.
No, I was just going to say that the point that's being made around records retention is a really good one, just from a risk management perspective as well. So in terms of knowing where your records are and to be able to provide access, but then also, you know, if you have retention schedules on them, getting rid of them when you no longer need them, because as long as they're in your possession or control, which is what Mike and Colleen have been talking about, then they're potentially subject to access requests, right? So it really is just a fundamental practice of good information management to get those retention schedules in place.
You know, and this might be a good time to bring up one of the, like, there's a couple that I had put together just from the OIPC, because we get lots of questions here as well. And one of the ones that had come up was there's often confusion around counselors and whether they can use their personal information, or sorry, personal email, and can they use their own computers to do their work. And I'm not sure if, Aaron, you're going to speak to that a little bit later, if now's a good time to chat about that, or if then now is a good time.
I think now's as good a time as any, and I'd really encourage the rest of the panel to jump in on this, because I tend to come from this from more of a government, obviously centered approach, right? Our client is government. We certainly help local authorities, but they're not our client in the same way that government is. And the practice within government has been to to completely move away from using personal email addresses and personal devices. Well, I shouldn't say personal devices, because there are technologies in place that allow you to use a personal device with various levels of authentication to be able to still conduct your business. But there's a clear separation between personal and business, right? So the problem can be, coming back to the point around being able to access certain things, if you're blending your personal and your business together, either by using one email or you're keeping your records in the same place, it becomes a little bit more difficult if an access request should come in for you to make the argument that no, this is my stuff, this isn't business related. So if you're using, I'm using my Gmail account to do government business, well, clearly it's not something that I should be doing with government. It's not allowed in government, but in the municipal sector, it's a little bit different for some. But it does make it difficult then to make that separation and say, no, this is just a personal account when you've demonstrated that it's being used for other things, right? So it makes it really difficult then to make that separation between work product and personal.
Yeah, we often, there's been a couple of reports that that the commissioner has put out there on this topic too, largely with government institutions. But same thing applies for local authorities. Like there's obligations under LA FOIP for the local authority, and the ability to meet those obligations when you have records being housed in councillors' personal email accounts or on their personal computers, it becomes really difficult for the local authority to meet its obligations for things like providing access. So if I'm a citizen making an access request and some of those records are on the councillor's in his personal or her personal email accounts, will those be searched? If searches need to be done to find all of the responsive records, is that possible to do that? So providing access becomes difficult, and the records retention and disposal, like we talked about, will those get captured in a record retention and disposal schedule? And if not, then they're sitting in somebody's email potentially when they shouldn't be, which poses risks, like you were saying, Aaron. So yeah, just it's being able to maintain control over your records, possession and control by the local authority. And I think that becomes really difficult when you have councillors using personal email or personal computers.
I agree. And on the other side of that, also the potential for a breach of somebody else seeing or looking at the documents when it's on your personal computer or laptop or whatever is a lot greater. And so you have some liability along that side of it too.
So that's a good question. Yeah. Like I've often thought that they should set up their own, if you're newly elected to council, you should get a new email address that's just, for your RM business. But what about computers, people getting the emails, from the office at home or something, or an email going from one member of council to another, but related to RM business? Do you think it's a good practice to issue a little laptop to everybody who's on council so they'll only use that for their municipal business? Might be a little expensive, but maybe that is the way they should go. I don't know.
It sounds like a great solution.
Yeah.
But I think you point to the issue for lots of folks will be the cost around it, right?
Yeah, yeah.
And I think there are technical solutions. I know within government, we can use our own personal devices, but you have to be set up through our IT folks, and there's two-factor authentication, print off of your phone, for instance, those sorts of things that I think you'd want to look into for the RMs, because it may not be, from a financial perspective, it may not be responsible to start buying devices for everybody, but there might be technical solutions.
Yeah. And that's beyond my expertise.
Do you guys see lots of questions around the division between constituency business and business of the local authority for councillors, and how there is sometimes not a division between that when it comes to records and Do you get many questions around that? Like we've seen some situations where there seems to be a convergence of what a councillor is doing for that would be considered constituency business versus business of the local authority. Do you guys see issues come up with that?
I can't say.
Okay.
Can't think of an example, but
Okay. Well, I'm going to move on in the interest of time because there is a lot of questions around coming in like crazy around municipal maps. So I won't open a whole can of worms on this, but I guess there was a ton of questions asked yesterday as well about municipal maps and whether or not you can include the names on them when making them available to the public. So I can see this coming up for things like hunters who want to be able to hunt on certain property and they want to be able to contact the owners of the land to get, permission to hunt. That would be an example of when it would be helpful. But does LA FOIP prevent the releasing of names of property owners on municipal maps? And from what I understand, the advice that our office has been giving out yesterday is that it definitely depends on the individual circumstances that are relevant in each case. So apparently there's a lot of things to consider for each local authority, whether they should be releasing the names on the municipal maps or not. And we haven't been giving a yes or no answer, but what I can reassure everybody about is that we are working on a blog right now to provide some guidance on the different things that local authorities should be considering when looking at that question. Is there anything you guys want to throw out there about municipal maps, just because there's just so many questions about it?
well, yeah, like I remember I don't know if the practice has changed recently, but it used to be that they would have the names of the owners, either registered owners or assessed owners. I'm not 100% sure, it might have varied. As well as the assessed value of property used to have all that information on RF maps. I don't know if that's standard practice now, but it's a tricky question because if you look at LA FOIP, the Act doesn't apply to published material or material that is available for purchase by the public or material that is a matter of public record. And of course, the names of registered owners is a matter of, you can obtain that information by going on to the ISC website, right? The assessed value you can find out by looking at the assessment roll the right time of the year. So arguably all of that information, LA FOIP doesn't even come into play, but I understand that, of course, the assessed owner is not always the same as the registered owner. It could be a lessee, for example, right? So I guess it's not a clear cut. I mean, I guess my inclination would be to say it's all a matter of public record. So what would be the problem putting that information on a map? But anyone else have thoughts on that?
Well, I think it sort of speaks to the nature of how information is changing and what is personal and what's not personal information, because there's so many sources for it now. And I think it comes back to ties back into the discussion we were having earlier around, what is and is not personal information. So in the past, where, you'd have to physically leave your home to go and find information, there's that notion of practical obscurity. It doesn't exist in a lot of cases anymore because you can go to various locations on the internet and piece together what you need. So that's where I think these kinds of questions are very complex, because it's not always as simple as just saying, yes, it is, no, it's not. There's a lot of other factors that come into play.
Yeah, definitely. One of the questions posed by one of the viewers is, what would be the difference between putting your address in a phone book and putting your name on a map? And I think, my first thought when I read that question is probably the difference would be is that you do have some control over your personal information and whether or not to put it in that address book, which is publicly available. I mean, you can opt out of having yourself in the phone book, right?
But you can't opt out of the
map,
ISC, right?
Yes, right.
You have to provide an address. It's not necessarily a home address, mind you. It's just a mailing address for purposes of land titles registry. So,
yeah. So yeah, the commissioner did want me to reassure everybody that a blog is in the works here. Hopefully it does help some of the local authorities that are struggling with this whole issue of municipal maps. But oops, sorry, I had it on mute. There are a lot of questions coming in, but I'm going to move on so that we can get through the 5 that we have here, and we hopefully will have some time to answer some more questions at the end. So this one is also an interesting one. How should municipalities handle situations where contractors, vendors, or ratepayers expect confidentiality? So we're talking about contracting and RFPs and that sort of thing. So who would like to start with that? How should they handle those situations where there's an expectation by the third party that there's some confidentiality?
Well, I can speak to that briefly, I guess. Oh, sorry about that. Sorry, can you hear that? Sorry.
Yep, you're good.
Sorry about that. I hadn't figured out how to shut that phone off, so. Well, we talked about before, like, of course, once a municipality enters into a contract with somebody, then the public has the right to see the contract itself. But I guess this question relates more to the things leading up to a contract, or contract may never happen. Of course, under, I think it's section 18, there's the exemption from access for communications that might contain financial or commercial information. Sorry, I'm oversimplifying it here. Yeah, financial, commercial, etc. information that's supplied in confidence, implicitly or explicitly to the local authority by a third party, right? It says the head shall refuse to give access to records that contain that sort of information. So a lot of the communications that might lead up to and records that might be created leading up to the entering into of a contract might be the type of records that you shouldn't be providing access to. Interesting question comes up, and there was a case, well, I've had a few inquiries, but relating to information that's obtained through the tendering process, right? And there was a case out of Regina here involving the Board of Education of the Regina Roman Catholic School Division a couple of years, I guess almost 3 years ago now, where they talked about a lot of the information that was provided in the tenders. Ultimately, the court decided that the school division in that case was correct in refusing access to the records. And basically on the basis of section 18(1)(b), on the grounds that this was commercial information that was supplied in confidence explicitly in that case to the local authority by a third party, which in this case were suppliers of computer hardware, I guess, or, the different companies bidding on it. So interesting, because there's a bit of a balancing act here, because on the one hand, it's important that anyone who participates in a tendering process can know that the tendering process was handled fairly. So at the end of the day, you want to know that they picked either the best bid, I guess. My understanding is normal practice for things like road construction contracts is all of the bids are reviewed. Typically, a consulting engineer might compile all the basic information and just put together a table, and here's all the prices, and normally, of course, they're going to take the best price. That information, all of the quotes, the total dollar figures will be public knowledge, and that's important for transparency and accountability, right? So that the public knows that they're making wise choices with public money, right? But what this case says is a lot of the underlying information, perhaps, unit prices or lists of equipment that somebody might have, or list of other jobs they're working on, things like that, that the council had every right to look at in making their decision. They don't have to disclose those kind of records. So any interesting situation. Again, it's a balancing the public's right to know and the other bidders, right to ensure that it was a fair process with the the ability of people who are in these lines of work to keep their pricing confidential, I suppose. So interesting problem. But don't know if anyone else has anything to add or.
Yeah, just a thought, not so much to add on to things that you've already talked about, Mike, but just I think there's part of the issue lies with the people that are putting in the bids to educate themselves as well about the legislation that they might be covered under when they're submitting these bids. So we see this a lot with the kind of things that Mike just talked about. There's an expectation of confidentiality, but not necessarily an understanding of what the obligations of the local authorities are on the other side to meet their transparency requirements and what the law requires of them. So I think there's a natural point in entering into those discussions with people who might be putting in bids on things to say, hey, you understand that we have some obligations here around the transparency and that some of these things might be public. So go back, have a look at the legislation, and they need to educate themselves about it as well. And oftentimes that's a piece that I think is missing for a lot of it, because there's this expectation that just by attaching the word confidential to something that it will never be released, but that's just not the reality of the world that we live in.
Yeah.
I would add to that too, that, definitely from our perspective, oh, sounds like there's a little bit of feedback. Can you guys hear me okay?
Yep.
Yeah.
Definitely from our perspective, private business that is choosing to do business with any type of local authority or government institution, it is the use of public dollars that are being used to do this business. And, government and local authorities definitely need the ability to do that business with the private sector. And that's why Section 18 of LA FOIP and Section 19 of FOIP are there, so that government institutions and local authorities can do business with public organizations and be able to keep what is sensitive confidential. At the same time, the other piece of that balancing act is for private industry to understand that it is public dollars, and there is a level of accountability and transparency that has to go along with the spending of those public dollars. And I do have a question on this point that's been put forward, and it's a question that comes up often with municipal councils. And it's whether local authorities must disclose all documents filed with submissions responding to RFPs or tenders. Often requests for disclosure come from competing contractors wanting to review others' submissions. What is your advice? Any thoughts on that? I know we have a review report out there. It was dealing with government institutions, not a local authority, where we did look at RFP packages. And we found in that case, consistent with other jurisdictions like British Columbia and I believe Alberta, that the RFP package did constitute commercial information under 19(1)B. So the equivalent of that would be 18(1)B under LA FOIP. Because they're not the successful bidder. I mean, we're talking about a whole bunch of businesses putting forward an RFP. The dynamic changes when you're the successful bidder. That's when there's some change that happens. But when you're just putting forward an RFP, trying to compete for a contract, our office has previously found in one report that RFP package is confidential and should be withheld under 19(1)B.
And I think, Alex, just to pick up on that, you had mentioned before about the guide to exemptions. I think that's a really good place for people to go and look at that particular section so that they understand a little bit more about the kind of tests that your office applies when people are thinking about those terms. So, what is technical information or financial information or those sorts of things. And really that, I think those exemptions are there to ensure fairness in the process and not give a competitor an advantage because they've sort of through the process now found out how to underbid their competitor. Right?
Exactly.
Access to information legislation was never intended to do that. and that's why you have that ability to withhold that information. So I just encourage folks that are listening today to go and have a look at that document and familiarize themselves with sort of what the tests are.
Yeah, that's a great piece of advice. And just to add to that, just so people know out there, that Chapter 4 of LA FOIP is almost complete, because we're just modifying Chapter 4 of FOIP. So the Freedom of Information and Protection of Privacy Act is very similar to LA FOIP, but there are some differences. Right now, you can look at Chapter 4 of the Guide to FOIP, and specifically Section 19, because the advice, guidance, and tests are very similar to Chapter 4 of LA FOIP when it comes out for Section 18. So look to Chapter 4 of the Guide to FOIP right now, Section 19, for that guidance. And soon we'll have Chapter 4 of LA FOIP up. Mike, were you going to say something?
Yeah, well, I was just going to add that the case I referred to, the judge paid particular attention to the wording of the tender documents, right, to support the finding that there was a reasonable expectation of confidentiality. So of course, what you say in your tender documents or in your request for proposals is important. And I couldn't imagine that, you would definitely be justified in saying that, whatever you submit will be kept confidential, so as to encourage people to give you as much information as possible to help you evaluate, right? So, yeah.
And just so people know too, like we were mentioning earlier, that once you're the successful bidder, that dynamic changes. And maybe to flesh that out a little bit more, what I mean by that is now public dollars are going to be put forward, and you're now in business with government or the local authority. Now we're engaging public funds, but it doesn't mean that everything is now wide open to the public. There's still plenty of situations where there is sensitive information out there in some of the documents going back and forth. But this might also be a good point to remind everybody about the provisions under the Cities Act, the Municipalities Act that we were talking about at the beginning, Colleen, where things like contracts should be made publicly available under those laws. So it's remembering that as well when we're looking at contracts with third parties, and remembering that comes into play as well.
Yeah, once you get through the process and you have a contract with somebody, that contract the public's entitled to see for sure.
So let's move on a little bit here. Now, we've maybe talked about a couple of things already, but what trends are you guys seeing out there? And is there any advice that you can share?
Well, maybe I'll start off the discussion on this one. And I'll just sort of reference the work that we do in our branch. One of our responsibilities is to produce an annual report about the activities under FOIP on a yearly basis. We don't have the same responsibilities under LA FOIP, so we collect stats around the use of the Act across government institutions, but we don't do that with local authorities. But I bring this up just to sort of highlight the point that the trend that we've been seeing for the last 5+ years is that the use of access to information legislation, of putting in requests, is on the rise. So within government, every year it's gone up, probably a good 10–20%. It's trending down a little bit this year, most likely because of COVID, and people, have other priorities than putting in access to information requests. But I would suspect that it's probably somewhat the same in local authority land too, that there's been an increase in the number of requests out there. So I think that, in general, the number of personal information requests has remained pretty stable, but it's the request for general requests. So the kind of things that we've been talking about, contracts or tendering processes, those sorts of things that would be on the rise. And I think it really ties back into a lot of what we were talking about before in terms of the need for good records management practices and the changing nature of records. That's another thing that we've seen a lot of, and this was touched on already around, emails. Are they records? Yes. Texts, as you begin to use new technology, for instance, if you were recording this meeting as a part of what a meeting with someone as a client, that might become a record as well. So the acts are older, and they tend to be sort of paper-based in the way that they're written, but we do have to keep pace with technology and recognize that the nature of what could be considered a record is also changing.
I would agree. The requests are certainly increasing. We hear from a lot of municipalities, as I'm sure the rest of you do, and they're getting a lot of requests and they're being surprised by the information that they have to release. And so I would be saying that one of the important things is that municipalities realize that they are a local authority. They're not like another private business, and how they deal with business is important, so that the kind of records that they have are, first of all, they know what kind of records are going to need to be released and accessible, and they plan around that in how they deal with their daily business. And just realizing, I think that, yes, that's going to be a record that's accessible. Those notes that you're scribbling about that person might end up being in an information request. And so you might want to be careful how you're doing your business and what kind of records you're actually keeping or not keeping. So I think that's a really important point, is knowing what's going to be accessible. Are your public disclosure statements accessible? Absolutely. It's clear. The public can have release of that. You are a local authority, a level of government, so it's different than just any other public business.
And in addition to what has been said, based on the emerging trends as a result of the request for access for information, my advice now in the municipal world would be, this is a time now for there to be best practices in place regarding every procedure or policies when it comes to processing access for information requests. For example, one of such would be something we had mentioned earlier. More and more people are getting to realize the need to separate work from, to separate personal life from work. So based on what we were saying earlier, I mean, it would be best practice at this time now to make sure to ensure that personal emails are separate from work emails. Another best practice at this point in time is to really have in place record management procedures, such as the ones we've mentioned already. And when it also comes to searches, that's one thing I don't know if we've said too much of. It would be best practice at this time now to document search, because we know that that becomes relevant at some point. For example, if an applicant wanted a review by the Office of the Information and Privacy Commissioner, that's one thing they want to know, what due diligence you've done when it comes to searches of such records that the applicant is requesting for. So this would be my comments on that one.
So you're finding that they're looking for how to respond to our office looking for details of their search? Is that how I understand what you were saying, Bacola?
No, I was kind of following up with what Aaron and Colin had said, that when we're getting, influx of more access of information requests at this time, it should be a call for municipalities to have best practices in place to deal with such. And those were my suggestions. For example, making sure, like we were saying earlier, I think it was Mike that mentioned the fact that it would be a good idea at this point in time for municipalities to look into the idea of having a work laptop different from your personal one, such that you can ensure that, you can ensure that your personal business is not mixed with work, based on what Colin was also saying about the fact that, you never know what will be accessible. And so making it easy to kind of separate the two areas.
Yeah, when you mentioned search, it right away triggered something for me, so I had to sort of clarify there, so forgive me. We are seeing a lot of search files, lots of applicants asking for reviews of the search efforts made by a local authority or a government institution. But you know, what we're finding frequently is that the local authority may not know what we mean by please provide the details of your search efforts. And again, going back to the guide to LA FOIP, in chapter 3, there should be a section on search, and it lists some of the things that can be provided when we're looking for the search efforts that the local authority went to locate records. And you know, one of the tips that triggered for me when you were talking about search is keeping track of where you've searched for things when you're actually doing the work. And when you talk about an extra laptop to do that work on, that's, you know, that's helpful, keeping it separate from personal, of course. But tracking the details right out of the gate in anticipation that the applicant may question whether all of the records have been provided or not, and if a fulsome search has been conducted. Because that's, if they come to us asking for us to look at the search efforts of the local authority, we would be looking for those details. And if you already have them, you know, tracked and written down as you're doing the work, how long it took you to look for records, what locations you went to, putting that down, it saves a lot of time later for you. But for local authorities, I think that the records management, again, going back to that, which I think you've all mentioned, is having good records management practices, because that comes into play when you're actually trying to respond to these access requests in an efficient way within 30 days, right?
So Alex, Bukola talking about best practices, I wonder, I know we were going to jump in at some point. We were thinking about showing folks where they can find some other resources that our branch puts out to support best practices. Would this be maybe a good time to show that?
Great time. Yeah, that was perfect cue right there.
So I'm gonna share my screen and just let me know if you can see that. So it should be the Google screen.
Yeah.
Okay. So this might be familiar to folks that are watching the call today or participating in the call today. But if you don't know, we do have a number of places where you can go to find some resources that might be helpful to you when you respond to access to information requests. I'm going to point out a couple. I just put in Freedom of Information Saskatchewan and Google, and these top 2 results are the ones that I wanted to guide folks to. So I'll open up this one first. So when you get to this page on saskatchewan.ca around access to information requests, if you just scroll all the way to the bottom, you'll find there's some videos here that'll help you with understanding some of the processes if you're not familiar with it at all. This is more for the public. The second one is the one that I think folks who are processing requests might find a little bit more useful. Again, at the bottom here, there are a couple of links to training. So this one is a training package that, oops, so I should just click directly on it and it should open up. Oh, no, of course it's not gonna work. Well, I'll take you to the Access and Privacy in the Government of Saskatchewan. I'll check on the local authority version. But this is one that new government employees take that provides them an overview of access and privacy requirements under legislation. There's a test at the end that you can print off. So this is one that we really recommend to local authorities in terms of just meeting your sort of administrative safeguard requirements around protecting personal information. So training your employees, this is a really good first step that, as I say, most government institutions use, and we really recommend to local authorities. The other piece that I wanted to point folks to is this one here, In the Door, Out the Door. And it's a user guide to processing access to information requests. And as it opens, what you'll find with this one is that it really sort of puts everything out step by step, from when the access request comes in the door to what you need to do to get it out the door. And it might be a little bit difficult for you to see on the screen, but it takes you through things like how to log a request, and what does clarification look like, and even as simple as setting up a file number, because I know that there's lots of local authorities out there who maybe receive one of these a year, or maybe they've never seen one before. So this is a really good resource for folks that might find that sort of guide useful. The other place that I wanted to send folks is to Publications Saskatchewan, because on that website you'll find all of the resources that our branch has publicly available to local authorities and government institutions as well. So if you go to the Publications Saskatchewan webpage, as it loads, just scroll down to government or external agency. This is why I wanted to walk folks through, because it's not as easy to find as it should be. You'll get into the government or external agencies and find Justice and Attorney General. And once that opens, again, you scroll down to categories, and right at the very top is access to information and privacy protection. And then it's split up into these categories. So you have your legislation, some general guidance, access and privacy. The access tab, this is what I think might be really helpful to a lot of folks. We have a number of model letters that you can use. So if you need to write a letter to an applicant, transferring the request, estimates of cost, extension of time, all of those things are here. So they're all there for you to use. There's a number of those.
Those model letters are fabulous, Aaron. Those model letters are fabulous.
Yeah, well, thank you. Lots of documents here and guidance around things like fee waiver requests and estimates and all of those sorts of things. So I know I went pretty quick to where you can find that, but it's all there. And if you need to reach out to us to help you find them, we're happy to do so.
One of the reasons I love those model letters is because at our end, what we often see in reviews is Section 7 responses are deficient. So they don't contain the elements that they should contain. So when the local authority responds to an access to information request within 30 days, we call that the Section 7 response. And it's missing a lot of things. So those model letters are fabulous because it shows all the pieces that need to be there. Citing the exemptions that you're relying on to withhold, including the right to a review, that sort of stuff. So we often see those things especially are missing, but so the model letters are great for making sure you've got all those components. So they're great. And lots of great resources on your guys' website.
Thank you.
So we had, the last question was tips and tricks. And I think we've kind of done a number of different suggestions here throughout the whole discussion. Is there anything burning that anybody would there as a tip or trick? And if so, let's throw them out there now. If not, I think I'm going to save the remainder of our time here to go into some of the questions, because there's definitely a need for some information in these questions that I'd love to get us through as many of them as we can. So are there any burning tips and tricks you guys want to throw out before we move on?
Nope.
Not for me.
All right. So let's tackle some of these. I just want to let everybody know that if we don't get to your questions, we will try to address some of them by email. We'll try to respond by email, but you can also send emails to us at webmaster@oipc.sk.ca. So after the conference, we'll still handle a number of your questions that way. So if we don't get to them today, don't worry. We'll try to respond to you. Or if you think of questions after, send them to webmaster@oipc.sk.ca. So the first question I want to throw out to the group is, can the public see a municipality's bank statement? Or is this an LA FOIP request? It isn't listed in Section 117 of the Municipalities Act. Anybody want to tackle that one? Can the public see a municipality's bank statement? Or is this an LA FOIP request? It's not listed in Section 117 of the Municipalities Act.
Well, that's a good question. I wonder if it would be, I know 117 only refers to accounts paid. Yeah, so it doesn't fit under that. And the financial statements are just a summary of the, what's happened over the course of a year. So yeah, it doesn't come under 117. Colleen, have you ever heard that question before? I mean,
Colleen, do you still have your sound? Is your sound still causing issues?
So, well, what I could say is, I mean, the basic rule is the public's entitled to access all records in the possession of the municipality, right? That's your starting point, unless there's a specific exemption or, unless it's personal information or something, right? So I guess the question would be to scroll through these exemptions and see if you could think of anything that would say that that's a document that's exempt from access, and can't
Yeah,
see.
I think it's a really good point to come back to off the start, Mike, is that the point of this legislation is that access is to be granted on a really, really broad basis, right? So
Yeah.
I can't remember who made the point before. I think it was Colleen who said, anyone from anywhere can ask for anything. So that's always a great way to think about the kind of records that you keep, and maybe what how you want to go about creating records and managing them. So I think Mike's right on point. You have to look at what that document is, what the purpose of it is, and is it something that could or should be released to the public? And if the answer to that is yes, then I think the way to proceed is clear. And if the answer is, well, we're not so sure, then you need to go back to the legislation and go through those specific exemptions and see, like, is this covered by any of these exemptions? If it's a mandatory one, then and you can make the argument that yes, we feel this mandatory exemption fits to it, then again, your path is pretty clear. You don't release it.
Yeah.
If it's one where you're not so sure, and maybe it's a discretionary exemption that you think might apply, again, you have to make the case that it does apply, and then apply it, still providing as much access to it as you can. And then you just proceed in that way. But I think it's really important to go about this thoughtfully and not think about it in terms of exclusive yes/no answers, like either we release it or we don't. Think about it in terms of, what's the purpose of the document? How much could we potentially release? And at the end of the day, you've thought through the exemptions, you've made your case around what might apply, and then you provide it out to the applicant, and they always have the opportunity to ask for a review by the Commissioner's office.
That's great advice. And I think the next question, you've probably nailed it there. The next question is, can a delegation to council be considered private information? And I think you've kind of nailed that in terms of the approach there, Aaron, right? How to come at that and making a determination. Can a delegation to council be considered private information?
Yeah, so unless a delegation was making a presentation to council at a point in time when they were meeting in camera and lawfully meeting in camera, in other words, the public was excluded, I don't see how. So, I mean, I guess in theory that's possible, but again, the general rule, as Colleen can speak to, is that the meetings of council are public, right? And
That's
you only
right.
can justify going in camera, in other words, excluding the public for very limited reasons. So it really depends, I suppose, on what that delegation was, what was the subject matter that they came to make some representation on. But I would, unless the delegation was legal counsel coming to have a meeting with council, I would think there'd be very few situations where, where what they said would have to be treated as confidential. And again, too, most delegations are meeting with council because they want to influence council's decision on some decision they have to make, right? And so that's generally speaking meant to be very public, I would think. Any comments on that, Colleen?
No, I agree. Sorry, I lost my volume sound here for a minute and I missed a little bit of what was said there. But no, I think I agree 100%, Mike, that if you're coming as a delegation, unless the topic is something that is legally able to be in a closed session, I agree. It would be something that is open to the public and the public can hear and can know about. So I don't think you can just, I mean, there's specific rules for council to decide on whether they can actually have a legal closed session or not. And I think they have to be cautious and conscious of that when they make those types of decisions. And the delegation should also know and be told that this is a public meeting and it's open to the public. And so whatever you say here will be, you know, available to the public.
In the case where a resident submits their opinion on land use planning decisions and wants it to be kept confidential, would we release their opinion, perhaps content of email, but withhold their name?
No. Again, if someone's making a submission to council on a land use and planning issue and hoping to influence council, it can't be done confidentially, right? So again, my advice is always return the communication. If it's an email, just respond and say, I'm sorry, we can't make any use of this unless you're prepared to remove this request that it be kept confidential. And again, that all goes back to this duty of fairness, right? You know, person's entitled to know the case they have to meet. And well, so you can't have, you know, representations being made on a confidential basis.
And I like the way you said that, Mike, because I think that planning, knowing ahead and being able to say to them, sorry, we can't use this information, as opposed to putting yourself as a municipality in the position of, do we provide this to the public or don't we? I mean, if they know ahead that that's your obligation, then that makes a difference and it's clear right from the top then. So I like the way you said that.
So for a discretionary use consultation, could we put it right in the correspondence seeking feedback that all responses will be made public knowledge?
Yeah, I think that's a good idea. Yeah. Yeah. Avoid then if, you know, then hopefully nobody's going to be sending anything in on a confidential basis because they should know better. Yeah.
What do you do if you, sorry, go ahead.
One other thought on that, Alex, is even just to take it one step further is, you know, on that whole notion of opting in is to, you know, have, if you're doing it online, have an actual box where people check off and right. Understand that, right? Yeah. So that by taking that action, they've then consented to the information being made public.
Which makes it so much easier on the local authority.
Yeah, absolutely.
Yeah. Mm-hmm. What do you do if you ask for information and any request is treated as an LA FOIP request and they charge you the $20 and tell you they have 30 days to give you a response? They are using LA FOIP as a means to not produce the information requested. That's a good one. Did I repeat that one?
Yeah, please.
I gotta get my head wrapped around that one. What do you do if you ask for information and any request is treated as an LA FOIP request and they charge you the $20 and tell you they have 30 days to give you a response? They are using LA FOIP as a means to not produce the information. So if I understand the question right, they're experiencing everything being made a formal access to information request versus just sort of informal and proactively releasing information, or do you guys have any thoughts on that?
Well, the problem with the question was the last statement at the end, because it concluded, it was a conclusion that they're not going to give it to me anyway.
Mm-hmm.
So,
or that they're using LA FOIP to apply exemptions to withhold things. Yeah. So this might be a good time to talk about, you know, the purpose of LA FOIP and why it's there.
My thoughts to that question would be that, you know, if the person is sure that what the information they're requesting is not part of the, you know, if they're sure that it's part of the ones that was stated in section 117 as you having the right to be able to inspect that one or get a copy of that one, then they have a point, and to bring to state the fact that they're being exploited by paying that if the information they are requesting does not require the formal process, the one we had mentioned earlier about the access to information request. They can just be requiring something that they're able to inspect and get a copy of without undertaking the usual process for a formal request.
Yeah, and I don't want to necessarily make more work for your office, Alex, but it would seem to me that that would be the place for them to reach out to on this one.
Yeah,
Yeah.
for sure.
Yeah, I mean, that's the thing. If they, at the end of the day, they refuse, then you seek a review of that decision. So, yeah. Yeah.
Absolutely. And if they've received a request in writing for information or records, then, engaging LA FOIP benefits both the applicant and the local authority, because it engages a process now for the right to review for an applicant if they don't like the outcome. And it also engages, some clarity around obligations on applicants for a local authority, so that everybody's on the same page and everybody knows the rules. And that right of appeal is engaged when you've got LA FOIP, and you've submitted a Form A for access to the information, or you've submitted it by email. But I think there's benefits on both sides for LA FOIP to be engaged. And it's definitely, a local authority is probably trying to follow the laws around access if they're engaging LA FOIP. So, that could be seen as a positive as well. So the next question is regarding tax enforcement. I have seen 6-month notices published in newspapers when an owner cannot be found. Notices include personal information. Should this be done?
Actually, the Tax Enforcement Act is explicitly asked for that Form C to be published in the newspaper if you cannot find the owner or do not know where the owner is. So in this case, I would view it as legislated.
Yeah.
And just to add on to that, subsection 28(2) of LA FOIP provides the ability to disclose personal information without the consent of the individual if another act provides for the ability to do that. So the Tax Enforcement Act would be an example. So on both sides, you've got that ability.
Yeah.
Can council say not to charge for LA FOIP requests?
I'm sure a municipality could waive the fee, yeah.
Yeah.
So one of the things that's in the documents that I had shown folks were to find on Publication Saskatchewan is some guidance around fee waivers. There's ultimately a policy decision, I think, for a municipality if they decide to go that route. There may be times when it makes sense fiscally and from thinking about their the folks within their municipality that they might want to charge those fees if it's a really broad request and it's going to require a lot of taxpayer dollars to respond to. But in other cases, they might have a case where it makes sense to not charge those fees. My advice on it would be to make sure you have a policy around it and that you apply the policy equally. So it's not something that you should do sort of off the cuff. There should be some thought put into when you may or may not charge those fees, and then have something that you can point to so that if there is a time where you've decided to charge a fee when you haven't in the past, you've got something that you can point to if that person goes to the commissioner's office and says, I'd like you to review these fees. Then you have something in place that you can point back to and say, this was our policy decision around this. It wasn't just an off-the-cuff decision.
Right.
This is a great time to point out that we do have a sample operational policy for municipalities on our website under resources, under the access tab, under elected officials. And it's just a sample operational policy to get municipalities going or local authorities. They can tailor it, tweak it. but it's just a starting point to develop some of the policies related to access and privacy. So I think maybe we'll take two. Sorry, go ahead, Colleen. Were you going to say something?
I was just going to say that was a great point, because consistency in how you apply things. I mean, not that there can't be opportunities or times when it might not apply or where you might waive it, but if you have that policy around it and you're consistent how you apply it, I think you save the municipality saves themselves a lot of trouble.
Yeah.
Yeah, I would add to that, you know, it is our office's expectation that all applicants are treated fairly. So you may not like, you know, Mr. Smith, and he might be a real pain in the butt in the community, but that doesn't mean that Mr. Smith pays a heftier fee than anybody else who asks for information, because he's just really, you know, difficult to deal with. So consistency, fairness, and when you have that policy, you're going off the policy, not off, you know, maybe some other subjective reasons how you're applying your fees or whether you're choosing to waive them or not. So yeah, that's a great point. How do we know that the request for salary information is legitimate? And if it is not, then are we still required to give out the information?
So the short answer is how they're entitled to know what the salary is and what's a legitimate reason for asking. You know, they don't need a reason for asking, right?
Yeah, yeah. Applicants don't have to justify why they want the information planning to use it for. And I think that's where you were going with that, Aaron.
Yeah, exactly. I was just going to say that it cuts right across the board. It's not just with those types of requests, it's with any request. We don't, it doesn't matter why they're asking, and we don't really get to ask them why. We just need to work towards processing it.
Yeah.
I'm wondering about emailing the meeting minutes to the council prior to being approved at the following meeting. Is this risky, as I have no idea who has access to my council's emails, including spouses and children, and should I be emailing them or not?
Yeah, I personally don't see a problem with that, because they're of no legal consequence until they're proved anyway, you know?
And I think this also matters whether we've got personal information involved, right? I mean, right away, my mind goes to, well, the meeting minutes are meeting minutes. It really depends what's in them, right? If we've got personal information involved, I think maybe that's where they're going with it, because it sounds like they're concerned about some privacy risks.
But if the minutes are accurate, I mean, that whatever's in there is going to show up and it's going to become a matter of public record. That actually raises an interesting problem, which is how much detail should you put into your minutes and into your resolutions? We actually had one claim once involving a complaint that council put too much information into a particular resolution, which the plaintiffs felt it was more information than was necessary. You know, claim got resolved, but the point is that's more a question about how much detail you put into the minutes or into a resolution, for example. But you know, to my mind, sending a draft of the minutes, that document means nothing. Once it's approved, then it becomes the minutes, and those are going to be a matter of public record. So,
yeah. Well, we are at 2:35 right now, and we've asked you guys to make yourselves available till roughly 2:30. So I think we'll maybe put the rest of the questions off to answer by email and let you guys get back to work. We super appreciate you guys being on the panel today and sharing your expertise with everybody out there. And we also want to thank the viewers, people who've tuned in today to hear the information being shared. And we would really like to encourage everybody in the audience to complete the post-webinar survey, which will pop up immediately when you leave the webinar. The survey is only 5 questions, and 4 of them are multiple choice, so it won't take very long, but that kind of information really helps us tailor the webinars and improve things at our end and meet the needs of you guys when we do future webinars. So hopefully you guys can all fill in that survey. And we're going to wrap up now. So thank you guys for being with us today, and thank you to the panelists. Really appreciate you guys coming out. Have a good day.
Thanks for asking.